must be there in the meeting. I'll start once again, just introduction part, Priyanka, don't mind.
Okay, ma'am.
Yeah. So this is the today's topic, company law. We are going to discuss about the company management meetings of our company management. And under this topic, we are going to discuss about what are meetings and the requisites or prerequisites of a meeting, and different types of meetings and resolutions. Tomorrow's class, we discuss only about the meetings, and next class, we are going to discuss about resolutions. So, being a company, being an artificial person created by the law, it cannot take its decisions on its own. So, the power of decision-making power of a company is given to the directors, board of directors or elected members, and these board of directors using these powers will conduct some meetings with the members and take the decisions relating to the business. And this decision-making in the meetings is under the democratic manner, that is through voting. So meeting means, in simple we say, where people gather and discuss about certain thing and take the decisions. Okay, so meeting generally plays an important role, especially in the company functioning, because meeting provides a platform for the shareholders to discuss and to share their opinions and take forward their opinions and the discussions, views relating to the functioning of the company, and enables the managers and the board directors to take their decisions relating to the success of achieving the objectives of the company. So these meetings constitute 2 persons at least, generally, okay, for a private company. For public company, minimum 5 must be there. Every meeting of a company must be has certain requisites where they must be informed to the members, and meeting proceedings has to be recorded in a proper way. And after the meeting, it has to be maintained certain record about the meetings that are conducted and the topics that are discussed in the meeting, which is called their minutes. Okay, and different types of meetings, time to time, for the purpose of smooth functioning of the meeting organization to be conducted. So now let us see the prerequisites of a meeting. To conduct a meeting, there are some requirements to be fulfilled by every organization. That is, before the meeting, it must be the person, the board of directors must make sure this notice is prepared and sent to all the related parties, a notice of the meeting, and which is also enclosed with the explanatory statement, which is called the agenda. So notice of a meeting sending to all the members is important before conducting the meeting, along with the agenda. And during the meeting, or to conduct the meeting, there must be minimum quorum for meeting, attend the meeting. Quorum means minimum number of members to attend the meeting, and chairman of the meeting must attend, and proxy also must attend. Proxy means a person who represents on behalf of the original member or the director of the company. Okay, and the next, voting. If in a meeting any decisions are to be taken, voting must be conducted. And once decisions are taken relating to the business matters, then those meetings turn to be a resolution. There are different types of resolution which we discuss in detail later. The next, after the meeting. After meeting means after completion of the meeting, it is must to maintain minutes of the meeting. Means the recording, the proceedings that are taken place in the meeting has to be recorded in a book, which is called as a minutes. And this minutes has to be kept open for everyone reference. And along with that, all the important documents, whatever circulated before and during the meeting, are to be kept and maintained in the registered office of the company. So let us see in detail about each of these requisites. So to conduct a meeting, proper convening authority must be there. That is board of directors and national company law, tribunal, or central government. Means if a company wants to conduct a meeting, the meeting will be authoritative to conducted by either the directors of the company, board of directors, or the central government or the company law tribunal, or authoritative to conduct the meeting. Okay, and the next one, as per the section 101 of the Companies Act, the important prerequisite of a meeting is notice. The notice is a form of written communication sent to all the members related to attend the meeting, along with the information relating to the meeting. That is the purpose of the meeting and the time of the meeting, date and day of the meeting, and place of the meeting. And this also under the below the meeting, this notice, the convening authorities will sign, and also copy to whom all this notice has been sent will be mentioned. How do they send the notice? Yes, the question is that how to send the notice. Yes, notice can be sent to the members either personally or through a publishing it in a well-known newspaper. Generally, a notice of a meeting must be sent to all the parties concerned at least 21 days before, the meeting for a normal meeting. So let us see about the next requirement, that is agenda. Agenda section 102 speaks about the agenda, that is, it is a statement of information which consists of the points to be discussed in the meeting. It is a statement which consists about the points that are going to be discussed in the meeting. That is, the purpose of conducting the meeting will be mentioned under this agenda. So that why do this is important? Why it is important to be given? Because so that the members attending the meeting will come prepare so that the time will not will be saved, and a proper and accurate decisions can be made possible to take. Okay, so agenda will be given. Agenda is a statement of business to be transacted and the decisions to be discussed, the points to be discussed in the meeting. Okay, so this enables the members to come prepared with their own opinions and perspectives or points to be discussed in the meeting. So this enables the members to take wise decisions in a shorter period without wasting the time. The next section 103 speaks about quorum. Quorum during the meeting. So this is about during the meeting. During the meeting, we said in order to conduct a meeting, there must be a proper number of members, a minimum number of members required to be attended. This minimum number of members again depends upon the company to company. That is, if it is a private company, minimum 2 directors if attend is enough. If it is a public limited company, minimum 5 directors required to attend. If it is a single man company, 1 person required to attend the meeting. Okay, so this a company, a private company, generally, a company, a public limited company, where minimum what do you call the minimum numbers to attend the meeting are above 1,000 to 5,000. Then they need to, there must be 15 members at least to attend. A normal meeting means 5 members attend is or more enough. But if the number of members to attend the meeting on the date of meeting are above the 1,000 to 5,000, then the minimum required to attend are 15 members. If it is above 5,000 members are supposed to attend the meeting, then the minimum number of members required to attend to convene the meeting are 30. In case of private company, as I mentioned, 2 members personally present at the meeting. As per the new Companies Act 2013, there is a one-man company also. In case of single person company, that single member must attend. Yes. Next, the quorum. If the quorum is not present, okay, to conduct the meeting, minimum number of members to attend, we said. If not attend, what to do? Yes, if the quorum is not attended within the time, half an hour from the time of commencement of the meeting, then the meeting will be adjourned to the next week on the same day, the same time and same place. Okay. If not, the board of directors must mention immediately, and the meeting, this present meeting is said to be cancelled. Okay, so if the quorum is not attended, the meeting within the half an hour from the scheduled date, then this meeting is stand to be cancelled, and this same meeting will be conducted next week, same day, same time, and same place. Okay, that is the requirement too. The next one is section 104 speaks about chairman of the meeting. Who can be the chairman? What are his functions? Okay, generally, chairman of the meeting designed or elected to preside over the conduct of proceedings of a meeting. He is the one who is elected to receive the meeting, and chairman may be appointed by voting or by show of hands. So who can be the chairman is among the board of directors, one will act as the chairman of the meeting by a appointment or by voting of the members. He is a person who undertakes conducting all the proceedings relating to the conduct of meeting. So what are his functions? Generally, a chairman of a meeting has to see that the meeting is conducted properly and as required by the law. Means all the requisites of meeting are adopted, followed, and conducted properly and smoothly. And he must also ensure that the proceedings of the meeting are recorded and maintained as per the rules of the law and maintained. Okay. And if a quorum not attended, he must make sure that the meeting is adjourned, and means maximum he must try to conduct the meeting as scheduled. Make sure with the members to attend the meeting as per the schedule. Okay, he can adjourn the meeting if required, but he need to pass some, yeah. He need to make sure that the adjourned meeting will be conducted in the next time with the all the requirements of the law. Okay. Yes. The next requisite we said during the meeting is proxies. Proxies, right? So as per the section 105, proxy means who? A person who appointed to represent to vote at the meeting on behalf of another member. In simple to say, a member who acts on behalf, a person who acts on behalf of a member, we call as a proxy. So proxy is a person who is appointed to act on behalf of a member, attend the meeting and vote in the meeting. Not all the proxies, okay? The instrument by which, so through some document, written document, this proxy will be appointed. Okay, generally, any number of companies and any other member of the company can be attended as a proxy and can vote in the meetings of the company. Generally, he's appointed, say for example, if I'm a member of the meeting and I can appoint some other person on behalf of me to attend the meeting as a proxy and vote on behalf of me. Okay, so let us see the rules of appointing a proxy, but it is not under certain, appointing any member as a proxy is under certain terms and conditions. Let us see what are those. First one is a company not having share capital cannot appoint a proxy. The company is not having share capital means among the members itself only running and no share capital, it cannot. So that is single company, single man company. He is only the single person. Again, how can he appoint on behalf of him someone to act as a proxy and conduct the meeting, right? That is one. Excuse me. The next one is a member of private company cannot appoint more than one proxy to attend on the same occasion. Okay. A member of private company cannot appoint more than one proxy to attend the same occasion. Means a private company member can appoint the proxy, but he can appoint only one proxy on behalf of him for one meeting. Okay. One proxy for one meeting. The next one is a person can act as a proxy on behalf of members not exceeding 50 and holding in aggregate not more than 10% of share capital of the company carrying voting rights. Yes. Now, see, third point I missed. Central government may prescribe a class or class of companies whose members shall not be entitled to appoint another person. Yeah. So first, a company not having share capital cannot appoint proxy. Second, a private company member can appoint only one person as his as a proxy to act on behalf of him. Thirdly, central government will prescribe which companies members are not eligible to appoint a proxy. Those companies means central government will prescribe some list of the companies. And those listed companies members are not eligible to appoint a proxy. Third one, so this is now a proxy, a person who's acting as a proxy. How many people, members, he can act as a proxy, the question. So then now that is a person who's acting as a proxy cannot act as a proxy for a maximum of 50 members. Means if I'm a proxy, I can act as a proxy for maximum 50 members, up to 50 members, not more than that. Okay. Or 10% share capital of the company carrying voting rights. Means if I'm 10%, whatever voting rights are there, if my voting rights are 10% of the share capital, then also I should not take up the other members as proxy for other members. So a person who's acting as a proxy should not act as a proxy for more than 50 members. The next one is proxy shall not have a right to speak at the meeting. He will not express, he will not enter into the discussions, he will not opinions. He just have a right to vote only in a poll. Okay. The next one is public company may appoint more than one proxy. If I'm a member of a public limited company, on my behalf, I can appoint more than one proxy. This one proxy is limited to certain shares. Okay, a proxy in how many proxies I can take is limited to the certain shares and different proxy for different types of shares. So, for example, I have a preferential shares and I have equity shares, and I'm also having a under preferential share different types. So, for each type of share, I can appoint a different proxies. That is only for the public limited company members. Next, a proxy is not continue for want of quorum to conduct a meeting. Yes, in the beginning I said the requirement of conducting a meeting. A quorum must present the meeting, I said. So quorum here in the sense the original members, the original minimum required number of members, not the proxy. Proxy is not to be considered as a quorum. Okay, so these are the rules relating to the appointment of a proxy. Yes, Priyanka, is it clear? Shall I move on?
Yes, ma'am.
The next section 118 speaks about minutes after the meeting. After meeting, it is required to maintain a record of proceedings of the meeting. A book which is kept to maintain the record of proceedings of meeting is said to be minutes. It is okay. In this, it is a statutory obligation for every public company or a private company. Both are required to maintain this book in which all the proceedings that have taken place in the meeting, whether the shareholders meeting or a directors meeting or a creditors meeting, to be recorded in this book. And this book, the entries to be recorded and completed, the entry of these proceedings of meetings to be completed and submitted in the registered office within the 30 days of completion of the meeting. It is must. And these minutes must be kept open for reference for every member of the company. And every meeting that is recorded in the minutes to be numbered, and each should be signed and by the convener of the meeting, that is chairman of the meeting. Okay, so whatever the minutes you recorded, all the details recorded in the minutes must be signed by the chairman of the meeting. So it must be in the printing, it must be signed, it must be numbered, and every page you must sign, put his initial at least for every meeting, and along with the initial, this chairman must also put a date. Okay, the next, yes, as I mentioned, it should be kept in the registered office for the circulation. Okay, and inspection by the members. Members must be provided this minutes record within the request of the member within 2 hours of the request. If I'm a member, I didn't attend the meeting, but I would like to go through the proceedings of meeting that took place in the previous meeting. Then when I request to provide the minutes record, then the register office people, the concerned people, authorities must provide me within 2 hours of my request. Okay, and they should not charge anything. No charges, within 2 hours they must be provided. Every member has a right to inspect the minutes book. If they want for inspection, they need to pay the fee. If a member finds any default has been made in recording the minutes, proceedings of the meeting, or maintenance of the meeting as per the section 118, will be punishable. Every officer related must be punishable with a fine up to 5,000. Okay. And if the if the failure is relating to not only recording, the relating to the compliance of provisions of the section 118, then he will be fined and imprisoned. Both punishments will be there. That's about the requisites of a meeting. Coming to the types of meetings. The company meetings are basically classified into 3 types: shareholder meeting, directors meeting, and special meetings. Under the shareholders meetings, you have statutory meeting, annual general meeting, extraordinary general meeting. And now at the present statutory meeting as per the new Companies Act, not that. But for academic purpose, you need to learn that also. Coming to the directors meeting, you have 2 types: board of directors meetings and committee directors meeting. Under the special meetings, you have class meetings and creditors meetings. Let us see about shareholders meeting. So I said statutory meeting has been abolished according to Companies Act 2013. Oh. Okay, now let me explain. I think this after this no slides. Yes. Okay, let me explain you about this statutory meeting. It's not there, but still for academic purpose, we need to know about this. Sometimes they take out the previous papers and give in the examination, you may get this question. So just have the knowledge of this. Statutory meeting, generally, private companies, it's not necessary to conduct the statutory meeting, but for public limited companies, it's must to conduct the statutory meeting. Means a meeting which is required as per the legislation. So what does this statutory meeting when to conduct? A statutory meeting must be conducted by the public limited company within 18 months of the commencement of business, corporation of a company. Okay, within 18 months, it must conduct this company. 1 second, ma. Just I'll share the other one. Just a minute. Yes. Priyanka, are you there?
Yes, ma'am.
So here is totally removed in this. Okay, anyway, I'll just tell you statutory meeting. So statutory meeting to be conducted by public limited companies as per the requirement of law, and before within 18 months of commencement of business they need to conduct. And what are the topics to be discussed in the the requirements for every meeting? Sending notice 21 days before notice to all the related parties. And what topics they conduct discuss under this statutory meeting? Generally appointment of what the minimum shares, minimum subscription raised, and what are the underwriting commissions, underwriting agreements they entered. Okay, all these topics to be discussed under the statutory meeting. And after the statutory meeting, a company must maintain a minutes and register this meeting within the 30 days of the meeting. Anyway, that was abolished now. Next, after statutory meeting, the next meeting of shareholders is annual general meeting. Annual general meeting is a meeting which is conducted by every company in order to discuss the business that has been transacted during the particular period of the business. Okay, so in this general meeting, the requisites as usual, notice has to be sent along with the agenda 21 days before the meeting to all the members concerned. And agenda, that is the purpose of this conducting this meeting, is to discuss upon the declaration of dividends, declaration of annual accounts of the company, and then appointment of directors of the company, if an appointment of auditors of the company, and their remuneration are the topics that are generally discussed in the general meeting. Okay. And directors report, auditors report, these all people will present their reports and also declare the dividend of for the year, and who are the people appointed as the directors and who are the auditors appointed as, and what the remuneration. Sorry, is this screen visible? I think no. I have to share this. Yes, right. So importance of then in this same annual general meeting only, sometimes certain important decisions also may be taken. For in such case, whatever the special business matters to be discussed relating to the shareholders, then this meeting will be come into the control of the entire affairs of the company will be discussed, and through certain resolutions these decisions will be passed. As I said, a meeting when conducted generally to discuss the annual events with some purpose, a simple ordinary business matters that remains as a. But when a meeting is conducted to discuss special business matters and take special decisions, then this meeting will be termed as a resolution. When decisions has been taken and passed, then these meetings themselves will turn to be a resolution. About the resolution in detail, we'll discuss in our next class. So here, the next one is provisions of legal provisions to conduct the annual general meeting. Yes, generally a new company, for the new company which is established newly and started the business, the first annual general meeting must be conducted within 18 months. 18 months from the first year. He said it's 9 months from the date of closure of its financial year. 9 months means, say for example, 31st, 21, they closed the books. First accounting year is closed on 31st March 21. Then the first annual general meeting, when they are supposed to conduct before 22 September. Okay, within 9 months, right? No, April, September. So April 22. Okay, April 22, 1st April 22, by 1st April 22, they must conduct the meeting. The holding of such meeting is compulsory for every company, whether it is public or private company. The subsequent meetings means the continuation of the meetings, whatever other next every year, whatever the annual general meeting is supposed to be conducted by the firm, that subsequent meetings are to be conducted within 15 months of the closure of the financial year. That is, here it mentioned that 6 months. 6 months means, say for example, 31st March 22 books are closed. Then by 30th September, they must conduct that year's meeting. Okay. So financial year usually 1st April to 31st March. So 31st March is completed for 1 year, and for that year's completed years of annual general meeting must be conducted by before 30th September of the financial year. Okay. So I say for the subsequent AGMs, first AGM within 9 months from the closure of first accounting year, and subsequent AGMs within 6 months from the closure of every financial year. Both are to be conducted as per the law. And that the gap between two AGMs, the gap between the two AGMs must not be more than the 15 months. Means almost every year they are required to conduct. Okay, the gap between two AGMs must not be more than 15 months. And the registrar, if period is extending more than 15 months, they are taking. They want to extend the time to conduct the next second AGM from the first previous AGM. Then the registrar has to be informed. They has to give the reason why they are extending and the time within which they are supposed to conduct the meeting. Generally, this gap again should not exceed the 18 months period. Okay. So I repeat once again, AGM, two AGMs must not be extended more than 15 months. The gap between the two AGMs must not be more than 15 months. If they are extending this time above the 15 months, the registrar they must inform. And this time also extension also should not be more than 3 months and should not exceed 18 months from the previous AGM. Okay. Yes. If required, if they feel there are no important aspects to be discussed, and every time at the meeting, whatever they conducted, they are discussing a general topics relating to the business, declaration of dividends, and no appointments of directors, no appointment of auditors are there. Then if they don't conduct also, no problem, but must be informed. Okay, the next, proper authority. Meeting must be convened by the proper authoritative person from the board of directors who have been given that authority to conduct the meeting. As I mentioned in the beginning itself only, notice, a prerequisite is sending before the notice, before the meeting, a notice has to be sent to all the members at 21 days before the meeting. How to send? Again, either the personally should be informed by mail or by postal address, or if not, through public notice. Through public notice in a well-known newspapers, meeting about the meeting can be conveyed to all the members. Okay. A meeting must contain all the details relating to the meeting. Notice must contain all the details relating to the meeting. That is, date of the meeting, date and day of the meeting, place of the meeting, time of the meeting, and also enclosed with an agenda mentioning about the matters to be, topics to be discussed in the meeting. This and to whom all this meeting has been, notice has been sent also must be mentioned. A copy of the director's report, auditor's report, and also to be enclosed along with the notice. Yes. Duration, the day and the place. Generally, during the business hours only the meeting has to be conducted and not during the national holidays. Okay, the meeting has been conducted either at the registered office of company or any other place, place which is known and located in the registered office of the company. Means, if possible, you must conduct in the registered office. Otherwise, the city in which your registered office is located, in the same city, any other place you can conduct the meeting. Okay. The next, the default section 97 provides that this AGM must be conducted as per the National Company Law Tribunal. The next one is penalty. If not conducted as per the requirement, as I mentioned already, 5,000 penalty will be charged. And sometimes the provisions of the law are not followed itself, then imprisonment and penalty both will be given. The next one is the next type of shareholders meeting is extraordinary general. Extraordinary general meeting is again the meeting means a meeting which is conducted between two annual general meetings. We call it as an extraordinary general meeting. Generally, the purpose of this extraordinary general meeting is to discuss the important and urgent matters which cannot be postponed till the next general meeting. This extraordinary general meeting will be conducted. In order to conduct this meeting also, the manager, all the directors, the person authoritative to conduct a meeting must give a notice. Actually, for the extraordinary general meeting, 21 days before notice can be given to all the members concerned with the date, place, time, and the purpose of the meeting. Okay. The board of directors, the quorum must be attended. In order to conduct every meeting, quorum must be there. It's compulsory, prerequisite. Again, where to conduct? In the registered office or in the city where registered office is located only. And if time is not sufficient, 15 days before notice also can be given. How to send the notice? Again, as usual, either personally or through public notice in the well-known newspapers. How many directors are required to attend the meeting? This is an extraordinary general meeting. The quorum minimum directors are supposed to be attended. If it is a shareholders-based company, 10%. The shareholders who are possessing 10% of paid-up capital of the company, share capital, must attend the company. And also in case of company which has no shareholders, 10% of the total voting powers. The members who are having 10% of voting powers must attend the meeting. The next prerequisites, again I said, meeting notice must be given to all the members, accomplished with the purpose of conducting the meeting. It should not be conducted during the national holidays, though it is an urgent matter. It should not be conducted during the national holidays. Okay, and meeting members, all the required quorum must present the meeting within the half an hour. You can repeat these prerequisites for every type of meeting while answering. Next one is a tribunal. Yes, if any reason it is impractical for a company to call the extraordinary general meeting, then the tribunal may conduct this by on its own motion or application of any director of the company or any application of any of the member of the company who is entitled to vote in the meetings of the company. This extraordinary means who can convene the meeting. Generally, company and the concerned authoritative person, when feels these matters cannot be postponed till the next general meeting, can conduct the meeting. Apart from this the authoritative person who can convene this meeting. As per the section 98, this for any reason, if a company is not able to call the extraordinary general meeting, and the members feel it is important to take the decision immediately, with the permission of the tribunal, members of the company, those who have the voting rights, can call for the extraordinary meeting, or the directors of the company whose names are on application can call for the voting of the extraordinary general meeting. Okay, then yes, here has been given an example, a case study relating to the rights of conducting the meeting. That is by the tribunal. So Pusi Dante and Rafiq Ahmed in 1999, there was a situation arise between these two directors and serious disputes between these two directors, which has led to deadlock of the management. Because of the directors' misunderstandings and disputes, the management has means the functioning of organization got affected. Okay, and a company so they failed to conduct the meeting itself only, extraordinary meeting itself only. Then the tribunal interfered into this case and called for the extraordinary general meeting. Okay, this is a case took place in the this. As per this, section 99 of the tribunal law says the provisions of 98 not complied. That is, conduction of extraordinary general meeting is not complied by any of the officers of the company by default. If they fail to conduct, they are supposed to pay a fine of 1 lakh and continue they continue the same default for a period more than the requirement, then they are supposed to pay 5,000 per day. So because of these reasons, this tribunal itself entered and conducted this extraordinary meeting of a company where these two people were held as a directors. The next one is class meetings. Class meetings means in between you have a dot negative dot. Board of directors will discuss after the class meetings. Shareholders meeting, class meeting, and board of directors meeting. So shareholders meeting we are seeing till now. General meeting and extraordinary general meeting. Class meeting is relating to creditors mainly. Class meetings, that is share capital of company, generally different types of shares we have, right? Preferential shares, equity shares, again under preferential, different types of preferential types of shareholders. So these shareholders can conduct the meeting time to time when the matters affecting the interest of these particular shareholders rights. Okay, so generally these are held by the some proposal to alter the rights and if some shareholder of that particular class feels their rights are getting affected, altered, and they need to be required to be changed. In such cases, these shareholders of that particular class can call for the conduct of meetings. Okay, the company say for example, preferential shares. Generally, preferential shareholders, if you take cumulative preferential shareholders, they have a right to get the dividends even in the years of loss. If a company getting losses also, the years of loss, the dividend to be paid in the years of loss will be covered by the company in the year when it gets the profits. So for example, if these shareholders are not being paid in the year when they got the profit, then the shareholders can call their meeting and conduct a class meeting with the directors and can demand for the payment of their dividends for those that is arrears of those dividends. Okay. So like that, every class of shareholder means every type of shareholders, whatever the number of types of shares are there, or the shareholders possessing all those, each of those type of shares, if feel their rights are affected by the acts of company, then they can call for a meeting and take the decisions. They can also pass the resolutions. Okay, the next one is creditors meeting. Same way, creditors also. If the creditors feel their rights are getting affected and they are neglected in payment of their dues or repayment of their principal amounts, then can conduct the meetings of their meetings and take the decisions. They also can pass the resolutions. Now, the next for these meetings also, or the prerequisites are to be followed as usual, like before meeting, after meeting, during meeting, whatever there, those are to be observed and followed. Now, coming to the next type of meetings, that is board of directors. The meetings by board of directors or meetings of board of directors. Here again, you have different legal provisions. The board of directors, in order to These are the people who have a supreme authority and power to conduct the business and take decisions, has the power to take the decisions relating to the company, various decisions relating to the company. So for the effective achievement of the objectives and the targets of the organization efficiently, these board of directors are required to attend the meeting time to time. See, these are the people who plays a key role in the business, right? And they plays a key role in the business, and it is not that time to time in a particular schedules only they meet and they take the decisions like shareholders or the class meetings. They are the people who, when and where, whenever requires, they have to gather, conduct the meeting, take the decisions very frequently also. So these the board of directors meet very regular intervals. Okay. So next one is that regular intervals. Legal provisions to conduct these meetings. As I mentioned, every company must hold the first meeting of board of directors within the 30 days of the incorporation. Because board of directors all must know and they should plan for their future, right? So once a company completed incorporation stage, within the 30 days for receiving the certificate of incorporation, these board of directors must conduct a meeting, and that is compulsory for every company. The second thing is that how much gap can be there between the two board meetings. Yes, the gap between the two boarding meetings should not be more than 120 days. 120 days means how many months? 4 months. Means they need to meet at least once in a 4 months. Understood? So board meetings, the two board meetings must not be more than 120 days or 4 months. Like in case of one company, one person company or small companies, dormant companies, they can at least half year once. One person, he is only the person, what he do, he is responsible for his business, right? So he can conduct a board meeting with his director 6 months once also. Similarly, small companies having few number of members, like below 1,000 or below 1,000 and all, can have a board meeting 6 months once also. But it should not be more than 90 days. Okay. The next one is that relating to this, the next requisite, the rule is notice. Yes. In order to conduct these board meetings, the board of, see, in case of shareholders meetings, the notice must be sent at least 21 days before the meeting, right? But in case of board of directors meeting, at least 7 days. It's only 7 days. Remember, for shareholder meetings, 21 days before the meeting, the notice must be sent. In case of board of directors meetings, 7 days before the meeting, notice must be sent. Okay, and that's all same. Written, it must be written, and all the directors must sign in and must be sent to their registered addresses, and or by post or by email or somewhat, but personally. Okay. Next one is, every officer of a company is responsible to give notice as per the act, and if not, 25,000 fine. Okay. The next one is, directors who are participating in the board meetings must personally attend the meeting or can video call or through audio visual measures. Means it is not necessary the director must attend the meeting personally only. He can attend conference, but no proxy. Okay, because he's the board of director. He cannot send a proxy because the proxy cannot express his opinions. He has only voting right, right? That's the reason. Next, quorum of the meeting. So conduct this board of directors meeting. What is the quorum? Minimum number required. 1/3 of the total strength of the directors. If a company has a 25 directors, 1/3, or 24 directors, 1/3 of that. That is 8 directors at least must attend the meeting. Okay. There are only 5 directors. How many must 1/3? Even 2 directors. So that is the quorum for attending board of directors. That is minimum directors to attend the meeting must be, or to conduct the meeting, are 1/3 of the total strength or 2 directors minimum, whichever is higher. Okay. The next one is participation of directors. Yes, they will also be counted for the purpose of quorum. If the director is attending by a conference, we will consider. See, remember, in a shareholders meeting, proxy is not considered as a quorum because he's attending on behalf of a main member. So he's a just proxy. So he will not be considered as a quorum. Here, in board of directors, there is no proxy. Every director must attend either personally or in video conference. And a director who is attending as in a video conference will be counted for the quorum. Okay, make it clarity. Yes. Here, one more point you should also remember. Vacancy director. What is the vacancy director? Say, for example, a firm has 5 directors in which one director has retired and in that place has been not filled. Then what is the total strength? 4 only we should consider. The firm has a 5, one has retired and that place has not filled. So the total strength to be considered as 4 only. And 1/3 of that 4 directors has to attend the meeting. Okay. The next one is time and place of meeting. Yes. In meeting, like other shareholders meetings, here also the notice must contain the date, time and place where they are conducting the meeting. As usually, it must be in writing and it should not be conducted during the holidays, and it must be conducted only in the register office or within the city where the register office has been located. The next agenda is, of course, notice must also enclose with the agenda which mentions about the points to be discussed, the business to be transacted during the meeting, and what are the matters to be discussed, the decisions to be taken. Everything has to be mentioned in the agenda. So this why this agenda to be so that the directors or the members who are attending the meeting will come prepare upon those matters and can able to take ideal decisions with a lesser time, within a minimum time. Okay. They can concentrate on the important aspects of the business to be discussed in the business rather than on the unnecessary aspects. The time of the organization will be served. Next, participation in board meetings, video conferencing. That means, yes, every director must inform his option to participate the meeting, whether he is willing to participate or how he is going to participate, and make necessary arrangement for such video conferencing and all. Means it's a common, no? When you when some person is ready to attend video conference and you don't have the video conference option, it's unnecessarily wasting the time and the money of the organization, efforts of the organization in conducting a meeting. So it must all the necessary arrangements has to be made. Excuse me. Next one is placing the director also should communicate his intention to whether he's intentional to act as a chairperson or not, must communicate it and must make all the arrangements. Next, placing statutory register at the meeting. Statutory editing what? Minutes, nothing but minutes. Okay, but to be placed in the board meeting as per the schedule. Maintaining confidentiality. Sometimes, sorry, till the decision taken, that is right from the beginning of the meeting to the end of the meeting, that is commencement and conclusion, the starting time and ending time. Everything that is discussed in the meeting has to be kept confidential. Other than the person means whoever the board directors, among those only these meetings related matters has to be discussed and must kept accessible only among these meetings only, these board of directors only. Minutes is different. I mean, after the meeting, all the important aspects will be submitted and entered, recorded, and within 15 days of the meeting will be placed for the public reference. That is the related members. And in these minutes, all the details relating to the who means when meeting conducted, what who are the people attended the meeting, what matters they discussed and decisions taken. All these will be mentioned. Okay, and has to be kept open the register office. Now, the people who are referring these can also give their comments in writing and can send their opinions. Voting directors, voting by directors, generally voting by board of directors can be show of hand. Proxy is not allowed. That is what they are allowed to attend the conference, video conference meeting, but not a proxy. Because these are the people who are important to take the decisions, right? Express their opinion and take the decisions. So decision making can be taken only by the director who knows the details of the business and how the matters relating to the business. How come the proxy can take, right? That's the reason why proxy is not allowed. Only the director personally has to attend. Either personally or video conferencing can attend the meeting, but by showing his hand, he can vote in the meeting. Okay. One director, one vote. That's it. That is especially no shareholders. In shareholders meeting, number of shares, one share, one vote, one share. But for directors, one director, one vote only. Okay, so that's about voting. Sorry, types of directors meeting. Under the class meetings, we have meetings of creditors. I already explained. Creditors who are all comes generally debenture holders. When their rights are getting affected, when the company violates in relation to the security offered to them or altering their rights, or in case of issue of new debentures or change in the right interest of the existing debentures takes place, these debenture holders can call for the meeting. Again, all the procedures and the legal aspects of the meeting are remain same as for the shareholders sending the notice, conducting meeting, information at enclosing the agenda, and after conduction of meeting, quorum, attending the quorum, and then maintaining the minutes, everything remains same. That's about today's topic. Meetings. In our next class, I'm going to discuss about resolutions. So when okay, our next topic is upon resolutions. Yes, Priyanka, are you there?
Yes, ma'am.
Stay here. I'll. Like adjust. I'll take a screenshot and leave you. It's closed. Oh. Okay. It's closed.